Good morning, good afternoon, good evening to all participants, depending on your locations around the globe. It is my great pleasure to welcome you to the second panel of this year's edition of Lisbon Law and Tech Conference, hosted by the Knowledge Institute of Abreu Advogados. This session will be dedicated to the topic of e-discovery. And I'll start with a question. How many emails do you think that are sent globally every day? The answer is more than 300 billion. And to that, you need to add trillions of instant messages, social media posts, documents stored in the cloud, metadata from countless devices. Now, imagine that you're investigating cartel behavior or some type of corporate misconduct, fraud, or corruption, and the evidence you need is hidden somewhere in this ocean of data, possibly across multiple jurisdictions in different languages. Some of it may be encrypted, some of it may be deliberately hidden. This is the reality of modern investigations, because as the world has gone digital, so has corporate wrongdoing. So whether you're a prosecutor or a compliance professional, the success of your investigation relies decisively on effective e-discovery, the process of identifying, collecting, preserving, and analyzing digital evidence, which has evolved from a niche technical skill to an absolute essential capability. And it's not just about mastering technology, it's also about balancing investigative needs with individual rights. It's about the interplay between national sovereignty and global crime, the challenges of international cooperation when data and cybercrime do not respect borders. It's about the speed of investigations to ensure effective enforcement and compliance when evidence can be deleted in seconds. Fortunately, for today's panel, we bring together a stellar lineup of speakers who deal with these challenges daily. Pedro Verdelho, Deputy Attorney General, who heads Portugal's Cybercrime Office within the Prosecutor General's Office. He has taught at the Judiciary Studies Center, which is Portugal's School for Judges, and he has been at the forefront of international cybercrime cooperation as Portugal's representative at European Union, the United Nations, and the Council of Europe. We also have with us two distinguished legal technology leaders. Bruno Massard, who leads Epiq's Latin American operations. Bruno has over 20 years of experience in corporate governance, risk management, corruption and fraud prevention with multinational firms, and has contributed to Brazil's largest corporate investigations. And Crespo, who is the managing director of Lineal, another legal tech in Brazil. He specializes in compliance, cybersecurity, data privacy, and e-discovery, advising multinational clients on investigations and incident responses. So I believe we have a very well-balanced lineup of speakers with complementary perspectives. On the one side, the public sector perspective, giving insights as to how public authorities are taking advantage of digital tools to render their enforcement more effective, and then the private sector approaches to explaining how our legal tech companies are assisting corporations in preventing unlawful behavior and dealing with investigations, and thereby also helping them become more innovative, more competitive and aligned with stakeholder interests, in my view. My name is João Melícias, and I'm the co-head of Abreu's competition regulation and EU practice. And as former executive board member of Portugal's competition authorities, I guess I bring both perspectives, so I'll try to bridge these two worlds. Over the next 70 minutes or so, we will discuss practical and legal challenges of e-discovery, explore impact cases, and look towards the future of e-discovery. Though we are all Portuguese native speakers, some of the participants following us online are not part of the 300 million who understand Portuguese, so we'll continue the conversation in English for your convenience. So let's dive in. I'll start with Pedro Verdelho and start with the beginning, which is detection of criminal behavior, finding culprits. What is, Pedro, the experience of the Prosecutor General's office in the use of digital tools to detect criminal behavior?
Well, thank you. Good afternoon, or whatever, to everybody following us. The first point, the criminal justice system is much different from the competition environment. Therefore, most probably my experience is very much different from your experience. Anyway, we always try to get evidence, and everybody speaks about these new tools nowadays, the artificial intelligence tools that we can use. By coincidence, 2 days ago, the Prosecutor General of Portugal made a public statement saying he's in favor of this kind of tools, but with strong safeguards. So the challenge is mainly to use this kind of tools with respect of the rights of the citizen. That is really the major challenge. Anyway, our legal system, as most of the legal systems across the world, we are reactive, meaning the criminal justice system is reactive. Most of the times we start with a complaint. Someone complains. So this is much different from the competition environment, because normally we start with a complaint. So we are reactive, we are not predictive. And this is very good for us, because this is a guarantee that will follow the rules, of due process, the rule of law. Many challenges because we have mass crimes across. So this model of reacting to a single complaint in some cases does not work. Just think on those mass crimes on internet. A criminal on internet trying to defraud someone does not try to defraud one person. He does it for dozens, thousands of people at the same time. So the model of starting an investigation with a complaint will multiply the complaints, will multiply the cases, will build very small cases when that small case is just the point of the iceberg of a big case with the organized crime. So this is a challenge, to use this kind of tools, but without infringing the rights of the citizens, and namely without infringing the very strong legal framework on this respect. And remember, even if we use this kind of tools, we are submitted to common tools in Europe, but also outside of Europe, such as the General Data Protection Regulation, that is European, of course, but is respected in a number of other geographic locations across the globe. Aside the 108 Convention of the Council of Europe and the 108 Plus, these two pillars impose to us a big respect on protection of data, on protection of the data of the citizens, and other regulations that you all of you know, namely the IA Act at the EU level also. So challenge, a starting point. This kind of tools will help us. This kind of tools will make our job easier and more efficient, but we still need to respect very strong safeguards. And we have indeed very strong safeguards.
Okay, thank you, Pedro. Yes, we are absolutely aligned. Indeed, when it comes to the antitrust or competition law forefront, agencies typically combine both proactive and reactive methods of detection. And when it comes to the proactive methods, let me also use this opportunity to showcase some of the work of Portugal's competition authority in the field of e-discovery. For a long time, the ADC has indeed used digital tools to detect anti-competitive behavior, for example, screening of e-procurement. you may know that Portugal is at the front of e-procurement, which has been mandatory in the country for I think almost 2 decades now. Meaning that every bid for a government contract needs to be submitted in an online platform, and this has given rise to a huge database of data, pricing data, stored in a governmental website, on which the ADC has been given legal access, permanent access, and on which it regularly runs screens to detect suspicious patterns of bid rigging, of collusive behavior. And of course, together with other sources of intelligence, this has enabled the ADC to build cases. Another example is web scraping. This time, this is meant to detect collusive behavior in digital markets. And it involves extracting pricing data in an automated fashion from online stores, marketplaces, price comparison websites, to detect, for example, algorithmic-led collusion when firms use a single pricing algorithm to determine their prices, or resale price maintenance, for example, in e-commerce. A third example is the detection of gun jumping in mergers. This is when firms implement their transactions, their mergers, without prior notification or clearance by the ADC. And by the ADC or the European Commission, of course. And I am told that the ADC is now using an AI-based platform which feeds from companies' public information together with language extracted from the media, that is news about companies' transactions. And because branding is key, the ADC has now renamed these methods of detection, because they're combined with AI, or they're powered by AI, as screen it, scrape it, and detect it, which I think it sounds catchy. But Pedro, going back to you, so we've discussed a little bit detection. I'd like to move towards collection and assessment of digital evidence. What challenges have you encountered in collecting and analyzing? For example, how do you handle, if you can share with the audience, encrypted communications in investigations?
That particular topic, encrypted communications, is quite sensitive. The European Union is studying the problem because it is a problem. But your question was, did these kind of tools change the criminal investigation? Indeed, changed it, and not only now, for a number of years. For example, on child pornography online, we are using online tools for a lot of years already to identify child sexual abuse material, for example. It is not a recent thing, it's a thing that is used in a number of countries already for years. But I would say not that it changed criminal investigation, but is able to change. And in particular, well, this was an example of something particular, child pornography, but this is not the case normally. Normally, you should think in other types of cases with billions of evidence. For example, cases with hundreds of email messages to study, in corruption cases, in tax fraud cases, or other corporate criminal occasions. So this type of cases with hundreds of messages, for example, or hundreds of phone calls, records of phone calls, or hundreds of pages of financial or banking information. In this type of cases, indeed, this kind of tools is able to change the scenario and to change the speed of the investigation and of the time. But I said is able to change. I did not say it changed because we are not yet there. Honestly, I don't think we are already there. It is used, this kind of tools are being now used. in certain cases, in concrete cases, they are used now in our courts in particular situations. But I said we are not yet there. I believe we will be, but we are not yet there for two reasons. The first one, we need to have fully reliable tools. That is, we cannot allow a tool to hallucinate. This is evidence. So this is not thinking, this is not deciding, this is picking evidence, gathering evidence, or better, analyzing evidence. And we cannot allow just 1 millimeter of bad analysis. So we need to rely absolutely on the tool. We need the machine to have absolute level of certainty, because certainty is something that we need to have in court, and all the thing is to analyze evidence, to present it in court, to use it in court. On that, I don't think we are there yet. Second point, the cost, the massive cost of this kind of tools. They are our Portuguese government announced a number of things on this field recently, but I believe they will need to obtain large amounts of money to have it. And besides, this investment sometimes is really absolutely temporary, because tools get outdated very soon. So for these two reasons, first we need to ensure that the tools are efficient, absolutely efficient, no hallucination or zero hallucination, or very, very few situations. And second, the technology needs to be cheaper than it is nowadays.
Thank you, Pedro. Indeed, if you have competition between suppliers, that will decrease the cost, hopefully. Now, let's follow up with Danielle and Bruno on the parallel evolution in corporate investigations. I'll start with Danielle. Danielle, you often have to move quickly, I suppose, in responding to breach situations. And what are the critical challenges you find in preserving digital evidence? For example, when it comes to the so-called chain of custody, perhaps you could explain a little bit to our audience what this is about?
Yeah, for sure. First, thank you. It's a pleasure to be here. It's a pleasure to be here with Bruno, Pedro, Maria. It's also like to say thank you to Abreu for an invitation. And about this question is a very interesting question, because when an investigation begins, and when I say investigations, it could be an incident response, it could be an investigation for compliance. I believe the biggest and the first challenge, it is time, because digital evidence is alive. It moves, it changes. A simple, for example, unlock of a phone can change the metadata. Cloud apps, for example, they sync in the background when you're not watching. For example, if you have an iPhone, you're sleeping, they sync with iCloud and they start working. So when you're facing a situation like that, I always say the first action must be freeze the scene. The idea of not analyze, not explore, not check, freeze. Stop the clock first to understand what's going on. This means, for example, if lock when it's possible, isolate devices from network, take copies in a way that does not change the original data. So that's the first step, understand exactly what's going on in order to move to the next step. So then comes how we do it. So companies like mine, Lineal, like Bruno, we follow standards for when we talk about chain of custody. So we have a lot of standards globally. We have ISO, we have NIST. The reason why we have that, because one day the evidence that we're collecting, that we are using, may need to stand in a courtroom or in front of regulators. It really doesn't matter. So if we cannot prove, for example, how an evidence traveled from the day one to the last day, then the evidence is weak. And it doesn't matter if the day one is today and the last day is in 5 days or 5 years. We need to have a document that explain exactly what happened, how that evidence was produced. So the chain of custody, it is not it's not a simple document. It is, we can set like a parallel here and say the chain of custody, it's like a story, it's a story of like of trust. So it tells who touched like the data, when, where it moved, and also that was never changed. That's why when you have a chain of custody, we have like the hash, we have the hash of the document, which identifies exactly when the collection started and how ended. So, and from my perspective, from my experience, I believe the hardest part here is not the technician part. It is the majority of the time people part. And the reason why I say that, because when you have like a cyber incident, or even an investigation starts, someone hires to help them, legal team want answers quickly. IT for sure, when like business running, security team, they want to like contain the risk, and for sure the leadership, C-level teams, they want to know exactly what happened. So that's why it's very important here to have like a crisis managed situation pre-set up, because if no one leads the process with clarity, evidence gets changed or lost. So that's why I say the people part is very important. If a situation, it's not a matter, it's when it's going to happen, the situation. So when it happens, we have to be prepared. You have to understand what's coming. So who is the leader of your company? Who is gonna lead, and who is gonna talk with like the vendor? Who is gonna talk with the legal team? Who's gonna help with the third party, or even who's gonna talk with like the legal team, the law firm that engage. So that's why it's very important, this communication internally and with like external. So for me, preserving evidence is not only about like the tools that we use. It's about patient discipline. It's about making sure that the truth that we are collecting will stay the truth for years and years. That in Brazil recently, I do believe we had a couple months ago the trial of like the January 8th, and that chain of custody there was big discussion for the defense. The majority of them explore a lot the chain of custody because we had a lack of the collections made by like the police and by the authorities. So a lot of like the defense explore the chain of custody, basically pointing and say, look, I don't believe the procedure, the collection procedure were followed correctly. So that's why I do believe chain of custody, it's very important.
Okay. Thank you, Daniel. That's crystal clear. Indeed, it can damage a whole investigation if it's not properly preserved, a chain of custody. Now, Bruno, in Brazil's largest corporate investigations, what do you find are the most common mistakes organizations make in these early stages of an investigation? Hi.
Hi, hello. Thank you. First of all, thank you so much for inviting me and Epiq to be here sharing all those things, specifically beside those giants from the market like Daniel and Pedro. So I'm very proud to be here. Well, jumping on it, if you go back and analyze a little bit the past 15 years on regards the discovery platforms, the forensic markets, we need to be realistic and see that those market forensic and discovery markets are a big asset from the consulting firms. From 3 years from now, at least in Brazil, the corporates is more frequently having its own environments to conduct internal investigations more professionally, taking care or starting to taking care on the best practices connected to the technology, discovery, and forensics. So the internal teams start to achieve better results with a much lower cost they use it to have by using e-discovery. That's in fact transforming how the corporations are conducting its internal investigation, and both simple and more complex case, as Crespo has brought minutes ago, where we really need, specifically for the complex case, we really need to take care on how we collect and all the details that need to be care in terms of the chain of custody, for sure. On the other hand, we need also to analyze that the maturity level of the internal teams on those corporations is still very low. And the level of investigation, I would say 80 to 90% from the investigation that the internal teams in those corporations that need to take care in the daily basis usually doesn't in fact demand a chain of custody or some proof on how the evidence has been collected, because 80 to 90% probably not going to the court. And when it's needed, a little complexity involving the investigation, and when it's probably going to the court, is more frequently, as long as I see for the Brazil market, that the company prefer to third-part this activity to companies such as Epiq and Lineal. But what I see that's being very transformative for the market, specifically for the professionals on this field connected to forensics, etc., is the current adaptation of those corporations by having their own e-discovery firm where they can be self-service on the investigations and use this every single day, not being dependent from third parties and other consulting firms that typically works with a high price to offer those type of investigations. So this is what I see that's being done by the company. Sometimes mistakes can happen, for sure, but it's a learning journey. It's a learning journey for the internal teams to understand a little bit when they need to care about the chain of custody, to make sure that the integrity of the data, because the data might be landing on the court, or when it's okay to only collect this more quickly and start and jump right away on the investigations. So I think it's a journey. It's a journey. When you see the consulting firms, they are more well prepared to deal with these more sensible cases. But I see that in the few years, we will have more and more professionals on inside the corporations being able to manage and to deal with those challenges.
Okay, thank you, Bruno. Another type of, let's say, management challenge you find in e-discovery, I think you touched upon a little bit on this, is coordination between teams. How do you solve this in practice? So coordination between, for example, the legal and technical teams in complex e-discovery investigations. Can you build a little bit upon that?
Yeah,
Daniel?
Definitely. Well, in general, what I see, and it's very reasonable, by the way, is that the lawyers want, in fact, to practice the law, not be dealing with technology in the day-by-day basis, right? Well, actually, Crespo is an exception, right? Crespo is a great lawyer and is dealing with technology every single day. But what I see is that once a lawyer understands that a lawyer that can manage and can, in fact, understand about technology, e-discovery, it becomes a harder type of lawyer that can be, in fact, a leader in this field. But when we connect experts such Epiq professionals, Lineal professionals, for those more complex cases that can, in fact, understand the lawyer's mindset, that's where the magic happens. So I would say that the secret for dealing between legal and technical teams is the collaboration. Collaboration for me is the secret on those fields.
Daniel, do you want to add something to
Yeah,
to Bruno's point?
for sure. And thank you, Bruno. I believe Bruno and I, we met each other answer this question, right, Bruno? Because Bruno and I, when I used to work in a law firm here in Brazil, and Bruno used to work for one of the big fours, and we had like a massive case. And as Bruno mentioned, communication was the key for the coordination. So I believe most of the investigations do not fail because of the lack of technology. There's a lot of technology nowadays that we can use. I believe they fail because people are working the majority of time in different directions. And that's why I agree 100% with Bruno when he say communication is important. So we have to remember, like, legal teams think like in exposure and rights. On the other hand, you have like the technical teams think like in terms of like devices, log, cloud systems, methods. So they're both right. Don't get me wrong, but they're not talking about the same thing. And I believe that's exactly the first step here, is to create one single question to everyone to follow. And this is the point that Bruno and I, like with Lineal and Epiq, we arrive. So we kind of call like, let's call like an investigation question here. So what do you really like need to understand? What decision are you trying to support? What truth matters? I believe once that is clear, everything becomes easier. So who should we collect data from? Which data sources matter in this case? Which dates matter? So the reason why I start saying that Bruno and I work like this massive case, because everything that I'm saying here, we had like days, months of discussions to understand exactly who should we collect data from. And one thing that's very important to say, we should avoid in all investigations collect too much data, because if you collect everything, it's actually the same as collecting nothing. If you have a lot of data, you cannot work with a lot of data. You have to organize everything. So review phase must be not about documents, but about the story that you're looking for. So we look like who talked to whom, if the conversation trends, if like when silence appears, when pressure increases. That's exactly how Bruno and I work in a situation like that, coordinating all the communication. So I still believe the key here is keep legal and technical teams talking very often. So, and everyone in this scenario moves together, and then the result will be there.
Okay, thank you, Daniela. I definitely hear you, because when training firms to prepare to dawn raids, I remember in the old days we tended to focus on the management teams, on the legal teams. Of course, they would need to be prepared. And now, I mean, it's the IT guys need to be at the center of it all, obviously, and coordination is also key. Now, Pedro, I'd like to draw a parallel here with criminal investigations. Do you see sort of similar coordination challenges, for example, between prosecutors and the investigation police in forensic analysis? How do you address these challenges if they exist?
In the challenges also, but not between the prosecutors and the police, because normally at that level we are coordinating. Our law is clear. The prosecutor should direct investigation, the police should execute investigation. I would not like to focus on that, but on two other things. First, fully agree with Daniel and Bruno. Collaboration, dialogue between the two tribes, the legal people and the technology people. That is crucial to make things work, because both tribes, let me call tribes to them, why not, have different rules. They have different protocols, they have different backgrounds. And if an engineer wants to obtain evidence from a computer attack, for example, he'll go there and he will obtain everything is there. But from the legal point of view, so as we can use that evidence in court, we need to follow different protocols. And this is not exactly the chain of custody mentioned before me for an engineer. For an engineer, the chain of custody is to keep the data totally as they were before. For me, that is not enough. I mean, we need to follow legal procedures. For example, in certain matters, a prosecutor needs to intervene personally. On other subjects, sometimes a judge needs to intervene also. So this kind of protocols, legal protocols, are the first challenge. Second challenge, most of the technicians, most of the computer engineers working on this type of matters, most of them work for cybersecurity companies. Normally, a cybersecurity company starts before, meaning building a system that can be secure, so that is not attacked, that is not vulnerable. So they are consultants for security, not for investigation. And this impacts the approach. When a company is attacked, for example, in a ransomware case, for example, when a company is attacked, the first goal of the cybersecurity team is to recover the system, because a ransomware attack totally paralyzes a system, a company, an hospital, a civil service, whatever. So the first goal of the cybersecurity company, the cybersecurity team, is to make it work very, very fast and soon, so soon as it may be possible. What does it mean from the criminal point of view? That they are destroying all the evidences. Let's compare it with a traffic accident. The main objective of the ambulances and the people from the services is, well, to keep the victim and transport the victim to the hospital so as a life can be saved. The objective of those that investigate the reasons of the traffic accident, is to keep it like it was, so as the evidence remains there. The two positions are extreme, and we need to dialogue about that, because if we just follow one, well, we cannot keep a company without a system for days and days and days, because they need to run the business. But if we follow the other one, we take the risk to destroy all the evidences. So these are different approaches, and the challenge on this respect is exactly to try to dialogue with the other team and to try to recover the system without destroying evidences, or leaving to the legal investigation, to the criminal investigation, a way to recover evidence of the crime, so as the responsibles for that crime can be identified and prosecuted and submitted to a trial.
Okay, thank you, Pedro. So coordination challenges still exist, but I mean with a different nature. I'd like to now dive a little bit deeper into how AI is transforming e-discovery. I know Pedro has already touched a little bit upon this, so I'll start with Daniel and Bruno. Can you share examples on how AI and automation are transforming document review, for example, in major investigations that you've handled? Perhaps Daniel, I'll start with you.
Yeah, for sure. I believe AI is changing the way we investigate, especially in compliance world, cybersecurity world. And that's because I believe, Maria, you start saying about like today we are sending 300 billion emails per day. But I would add also that I believe in the future, we're going to reduce the amount of data in terms of email that are produced, and we're going to increase a lot the amount of data that are used for phones, for example, WhatsApp, Signal. And it is how we're changing a little bit, and that's how AI is important. For many years, for example, investigations were about documents. We always asked, what do we have? What did someone write? Is there a message that proves something? It was a piece of paper. So that was the case. But in real cases, especially like in corporate misconduct, fraud, internal incidents, there almost never a sentence that explain the truth. So people almost never incriminate themselves in writing. So I would never write, so, hey, Bruno, let's commit a fraud today. So the key here is what they leave behind. It is not a message. It is what they leave is like their behavior. It's exactly how AI gets here and how they help us. So the AI becomes essential to understand this behavior. Instead of using AI to search for keywords, which we use a lot in the past, we can use AI to ask, to help us understand when, for example, a behavior changed. We can use AI to understand like the sentiment analysis on a written sentence. So we can also, for example, when conversations move away from the official channels. So if you have Teams message, you have Slack, you have emails, and then you identify that the conversation moved to another not official channel. So that's behavior. So when people start like you avoiding written communication during key decisions, that's behavior. So this is critical for in our world in terms of compliance, in terms of cyber, because compliance it's not just like having like policies. So we have to policing people. It's not that's it. It is about like to understand how decisions are made and how influence moves inside of the organization. So it's the idea here if someone suddenly starts making decisions they never made before, if discussions that were clear become coded, if approvers that used to involve like multiple decision makers become very fast and concentrate. So that's how AI gets in the game and how help us to see that pattern. So that's the same for investigation. That's the same for cyber. Most security incidents, for example, are not discovered because of a malicious file. They are discovered because the behaviors change. So we can see like logins at unusual hours, access to instance that use that user never used before. We have like large file transfers without like any business explanation. We have account switching over. So AI can help us detect uh, all these examples in seconds. They can prevent the breach, or it can prove that a breach was intentional. That's the idea, for example, that we have. And it's why, for example, we use, Bruno and I, we use, for example, technology. For example, if you have, we were reviewing like a WhatsApp and Teams message. Even if there was no like a smoking gun message, we can use AI, for example, that to show right after certain events, a small group stop using the official channels, switch it to like a short, fast message at the same time in the same day, avoiding specific channels. So we can say that they're moving the pattern to something else, and that could trigger initial fraud, for example. So I would say that AI here, it's here to make human judgment deeper and more precise. I'm totally against when people say hey, AI, it's here to replace lawyers, it's here to replace investigator or analyst. It's exactly the opposite way. AI is here to help us, to help increase our judgment and give us more power than ever. So it will help us to reveal the truth. It will help us to reveal the invisible, and it will help a lot us in an investigation or even a cyber incident.
Okay, thank you, Daniel. Bruno, what's your take on AI here?
Well, we have currently several tools that not only AI, but with machine learnings that help and speed up the doc review process. So, for example, Epiq has built and put in the market by the beginning of this year a solution that's Epiq AI Discovery System. Just to give you an idea how powerful the solution is, it can review up to 500,000 documents an hour. So you imagine that you can also interact with your documents, asking questions, getting answers, finding missing items that a human maybe could miss in terms of the context, in terms of the history that the evidence have. So we can, in minutes, in few hours, identify very important and relevant documents for small or large investigations. We can build portable models, AI portable models that we can apply for similar case to speed up the investigation process. So all those AI tools can, in fact, transform the way that the investigations is being done and helping the lawyers to focus on the main important party of its jobs that define the strategy and protect its client, right?
Thank you, Bruno. Pedro, having heard from Bruno and Daniel on the use of AI in corporate investigations, I know that you've already touched a little bit upon this subject, but I'll ask again the provocative question, because in Portugal, the length of criminal investigations, well, fairly or unfairly, but it's perceived to be excessive. I mean, many criminal cases get sometimes barred on appeal and crime is left unpunished. Do you think AI perhaps could help, could be part of the cure here, even if we're not there yet?
A part, yes. A part of the cure, yes. But just a part. And okay. I'm not sure if it is a big part in any case. I already said it. These new tools can accelerate the process. All of us have read in the press or seen on TV that in big judicial cases, for example, of financial fraud or economic crime, sometimes the expertise takes like 2 or 3 years. So a human expert needs a lot of time to analyze documents, etc. And in this particular aspect, yes, I would say that AI can be a part of the cure, namely where the cases have hundreds or thousands of documents or banking information or so. But this cannot be, it's a risk, and we need to avoid the risk to believe that this can be the cure. This cannot be the cure. This is a part of it, but in the judicial system, there is a number of other measures to unblock what is not working well.
Yeah, absolutely. Human judgment will be, the final decision on the matter. Now, going back to Daniel and Bruno, because this panel is about impact cases, I would ask you if you could share a significant case or investigation where e-discovery was paramount, was fundamental for the success of the investigation.
I will start with the case that I just mentioned, and I work with Bruno actually, so I believe that's the best example. It's a public case, everyone knows here in Brazil. It was during the car wash operation back to 2014, 2015. Bruno and I, we play different roles for Eletrobras, which like at that time was the biggest electrical company here in Brazil. And that was a massive case. At that time, I was working as attorney for international law firm, and Bruno was playing the other side in the shadow investigation. So back to 2014, 15 here in Brazil, we didn't have a lot of technology available. So e-discovery and all the tools that we have today, they were crucial to help us speed document review, understand what was going on. So I believe at that time, it was the first time for us that we had technology to review data. For example, it was the first time that we had, like in a large scale, the use of relativity, which is it is the biggest document review tool that we have in the world. It was the first time that we had, for example, talking about data analytics. It was when we kind of use in a massive way BrainSpace, NextLP, and all like the data analytics tools that today are kind of people are very familiar. But back then, it was no one ever heard about any of these things. So I do believe e-discovery, it was the key to the Eletrobras investigation that we had in Brazil. So we have like over than 40 million documents to be reviewed. Can we imagine review all these documents without technology, without having all the technology that we have available? So I believe that was for sure in Brazil the key point and the changing point for the technology and where we are right now. So I don't know if Bruno, you do agree with me. I believe at that time we started changing a lot the market with that investigation.
Bruno,
100%.
would you like to follow up? Yeah.
Yes,
Go ahead.
100%. I agree 100% because if you go back to those dates, I'm thinking on the Eletrobras investigation, and it would be very honest. Even if we analyze the technology infrastructure from the consulting firms at that time, it was not that advanced as at that time Hogan Lovells has brought to Brazil to conduct this investigation on Eletrobras case. So if this investigation was expensive, imagine if Hogan Lovells did not use AI and technology and the appropriate technology available at that time to conduct this investigation. It would be insane. But what I want to bring here as well is that not for a specific case, but just thinking on machine learning. That's like some steps before the AI. If the company is currently using machine learning for doc review, for example, they will do on doc review side about 30% from the time and from the cost that if they do a linear review. So you see that how much machine learning can decrease the timetable and also the cost of the investigation. If you connect the machine learning with AI, definitely this timetable and cost might be reduced in 90%. We are speaking on machine learning decrease this in 70%. If you go to combine machine learning and AI, the investigation probably will reduce timely and also in the cost about 90%. So it's not a nice to have solution. And of course, we know that all the new technologies and the technology might have some type of hallucination. But remember, humans also have conduct mistakes. So a human work also need to be reviewed. Why an AI work should not be reviewed? Of course, all the results need to be reviewed. Doesn't matter if it's been done or supported by AI, by technology, by machine learning. But everything need to be reviewed. The final results is a human responsibility in the end of the day. So in terms of timetable and in terms of cost, it's no way back. We need to get adapted to it.
Okay, that's clear, and I imagine that the car wash experience must have been a learning experience for all the industry. Now we've talked about technology, management, and technical challenges. I'd like to discuss a little bit the legal challenges of e-discovery, particularly in the context of cross-border investigations, which Pedro touched upon in his introductory remarks. I'll start then with Bruno and Daniel. What are the biggest obstacles you find in international cooperation and cross-border investigations? I mean, what practical advices, for example, do you give your clients in these contexts? Perhaps Bruno. I think you have, yes, you're in mute, Bruno.
Yeah, sorry, I have put him muted before. So, yeah, I think that one big challenge when we are speaking about cross-border case is the language is a big barrier, because when we have people speaking, it's different when you say that someone has a fluency or it's a native in a specific language. A very good example that we can bring from a case that Crespo and I have worked together in the past is that the AI solution was pointing to an evidence that has a saying from an advertised company in Brazil that for people abroad wouldn't make no sense. When people from Lineal teams jump on it and reviewed the document and say, wow, I don't believe that. This is the way that these guys are asking for bribes. So the cultural aspect, the language, native language, it's a very big aspect that need to be taken care when we are conducting an investigation, because fluency doesn't help in this way. Another challenge that I see is very specific for European market, because the GDPR is a very, very strong and important privacy law that need to be followed. And if you have a case that being running in Brazil and somehow we need to, in a multinational firm, and somehow we need to conduct a case in EMEA, thanks God that today I'm in a very global firm that we follow all the same procedures and I can reach out my team in Europe. But GDPR have this challenge where I cannot, for example, collect and review the data from Europe, from Brazil. So I need to pass all the things to my European team. So those are two big challenges, but I think language and culture and the privacy are the biggest challenge that we can face when we are speaking about cross-border case.
Thank you, Daniel. Bruno, would you like to follow up?
Oh, the opposite. I believe I agree with Bruno, actually. Language is always tricky when you're talking about cross-border investigations. And also the privacy, especially in the last, I would say, 5 years, more than that, with the GDPR and in Brazil with LGDP, cross-border investigations are where the rules of privacy and the needs of the investigations meet. And what we have to understand, for example, it is both of laws. When I say GDPR in Europe and we say in Brazil here LGDP, they're kind of quite similar, and they require what? They're requiring we have to use the least data possible only for a specific purpose. So if we're talking about cross-border investigation, you have to understand what is the purpose of this investigation. What is the legal support that we have here? And that's, I believe, also privacy is an issue, but we have to remember that when we are working on investigation, all the investigations require speed. That's mandatory. Everyone is very anxious, so they require speed, they require access, and they require the ability to analyze all the content. And these are kind of factors that forces a conflict. So I believe the first approach that I would suggest in a cross-border situation, the first thing we must define the legal basis before collecting anything, because moving to the next step. Because once we have that, it's going to be easier, for example, to set up where you're going to keep the data. It's going to be inside of Brazil, it's going to be inside the US, it's going to be in Portugal. So, and we'll move data only if necessary. But I believe that's the key pace of like this cross-border investigation. I believe my very end advice here is do not try to build privacy investigation guidelines during the crisis. So you have to be prepared before. If you like in a multinational company, prepare before the incident or the investigation happens.
Yeah, preparation is the key to success, typically. Now, Pedro, you've been working on international cooperation for nearly 2 decades. How has the data protection landscape we've been hearing about changed the game in your experience? How do you balance sort of investigative needs with the data protection rights in these cross-border cases?
Well, let's start by a disclaimer. As a European citizen, I'm very happy that we have data protection laws. So I'm happy that my personal data are not in the market as a product, as something that can be sold to someone for example, marketing purposes. This is a disclaimer. After saying that, most of the investigations regarding the internet are international. That is, it's not even probable that we have a criminal investigation without any international connection. For example, if someone sends a threatening message to another person using a Gmail, this is already a quite dangerous international crime. Why? Because Gmail is not in Portugal, even if the victim is here, if the victim and the perpetrator live in the same house, for example. And this is something that occurs with domestic violence sometimes. So this is international. And I don't think I need to explain more why everything that occurs on the networks is international. So international cooperation is crucial. This was in fact the second disclaimer, because the first regarded data protection. Data protection is a very big issue to criminal investigations for itself, and also because we cannot cooperate with countries that don't have data protection laws. For example, the Portuguese authorities and the European authorities are authorized to cooperate with Brazil because in Brazil there is a good data protection regulatory framework. But not with Chile, that is aside, because they don't have yet, even if they are drafting it. So this is a limit, this is a barrier to international cooperation and to obtain evidence in these investigations. And remember, all of them are international, and only a part of the countries in the world have the data protection regulations. The United States, for example, they don't have. A number of Asian countries, they don't have. And also in Latin America and Africa, a number of countries don't have. So we are not authorized to cooperate with authorities of those countries if the issue is data protection. And in criminal investigations, most of the investigations include personal data. On the other side, your question, balance. Well, the criminal prosecution laws are weaker than the data protection laws. I repeat, the system is not balanced. The data protection rules are limiting investigations. In fact, the data protection component is heavier than the investigation procedural rules. So the data protection rules are really jeopardizing some of the investigations. And this applies internationally, but also domestically. We have very clear sign of that recently in the last 2-3 years with discussions at the Constitutional Court regarding the metadata law. This is not probably important for most of the audience, but the question is that our Constitutional Court, for data protection reasons or for the principles of data protection, the Constitutional Court, I said, declared unconstitutional the data retention law, a law that obliged the providers to retain certain types of data so as they could be used in criminal investigations. And we don't have any obligation now to the providers to retain data, any type of data. So this is a good example. Our data protection rules are heavier than the criminal investigation system.
Yeah, I do hear you, Pedro. The data protection in Europe is quite burdensome. I also enjoy that my privacy is well protected, but the fact remains that it has given rise to a lot of even market distortions, because those that could better adapt to those laws were, the usual suspects, the big ecosystems. Perhaps a sort of simplification or an omnibus package applicable to the GDPR would be welcome. Anyway, so we've covered technology, AI, legal challenges. Now, let's look forward to the future. So I'd like to ask all of you, where is e-discovery heading? Whether you see the biggest challenges and opportunities in e-discovery for the next 5 years, starting perhaps with Daniel.
Yep, for sure. I believe for sure about everything that we discussed today, the future of discovery for sure is not about documents. It is about conversations. For the last 20 years, organizations believe that email was the center of the communication, and it was for a long time. Email, it's clean, structured, archived, and then easy to search. And because of that, I believe we built all our investigations models around emails, but that reality is gone, and that will change even more in the future. So today it's very important. People do not making decisions using emails anymore. The majority use right now, all the decisions are now faster, but they use WhatsApp, Teams, Slack, SMS, Signal, iMessage. It doesn't matter. So it's all the new apps are changing the communication, and now communications has moved into a fast, short, and emotional exchange, not the long written paragraphs. So because of the communication channel, the evidence also changed. So that, I believe, what we're going to see the biggest chance in the future, it is everything around the communication and how we communicate and the kind of evidence that we produce.
Okay. And Bruno, how does the future look like for you in e-discovery?
I would focus on the opportunities. I see that e-discovery is becoming more popular. More big firms, corporations are having its own environment. So I see this as a big opportunity to the professional that currently are conduct internal investigation manually without have the appropriate technology, to become more digital investigators. There is no much professionals with those capabilities, at least in Brazil. So that's for me the biggest opportunity for the professionals.
How about you, Pedro? Where is e-discovery heading, perhaps from the point of view of regulatory evolution?
I think that the future of discovery is going to be very much driven by the evolution of technology. So, for example, in the last 10 years, we have seen Yeah, indeed. One of the issues that is a key in the criminal justice system is certainty. You need to know the law before you commit a crime, otherwise it will not be a crime. And so we need legal certainty, and regulation is indeed a need for the future. But not only certainty regarding laws or regarding the legal framework, also certainty on the result of all those methods. I already mentioned it before, but we need to be sure that the systems really are effective, really are reliable, and besides of reliable, also transparent. We need to be sure that a system used by someone will produce a result that with another system, for example, from another company, will produce the same result with the same source of information. So we need certainty because lawyers need certainty. Anyway, there's another point of view, and this is technique. So this is a technical challenge. Anyway, there's another point of view, and this is somehow confusing for myself. We live in the era of speed. Everything is quite fast. We need to move fast, or otherwise we'll become outdated, we'll become out of the market. And AI is a good example. Suddenly, everybody speaks about AI. Everybody speaks about these new methods, how this will be changing the world very, very soon. And we need to be there, otherwise we'll lose the train. Indeed, the train already departed the station on this issue. And we are not just getting it at the station, we are already moving. So we need to take care of that, we need to take care of speed. But I believe it is still true what the old Roman said, what indeed the Roman law said in Latin, festina lente, that is, if you want to go far, you need to go slowly, otherwise you will not arrive there.
Yeah, that's a great poetic note as we approach the final stretch of this discussion. Would you like to share in 1 minute, 30 seconds, some final thoughts, some key takeaways from this discussion, or perhaps a piece of advice you'd want to give organizations who haven't yet embraced modern e-discovery? Bruno?
Well, I think the takeaway for me in terms of e-discovery is personal development. I would advise specifically the new professionals, the ones that are on the journey on its career, it's to don't fight against technology and AI. Technology and AI will not take your job. Someone who understands and properly use it maybe will. So that's my big advice for the professionals that are on the journey of its career, is think it can be a very big development.
Thank you. Daniel, would you like to share something?
Yeah, for sure. I believe I really like what Bruno said about embracing technology. I believe that's a key moment that we're living right now. Things are changing very fast. So just to mention about the speed, and that's true. I believe our scenario for the future, it is speed and new technology. And I believe one thing, if I have to leave one message about everything about we said today, preparation wins always. So not tools, not budgets, not speed, preparation. So we have to be, companies must be prepared. They must understand everything that's available, all the tools that are available, and prepare themselves for the future. So I would say that's why I say preparation is the key for the future. Thank you.
Thank you. Pedro?
I would
Another
leave 2
poetic
words.
note, perhaps?
No, I'm not a poet. I would leave 2 words. AI, of course, will be useful in the future, but at least from the criminal justice point of view, it's also a problem. And with this, I come to my 2 words. Regarding this last, the problem, it does not work to avoid problems that exist. So we need to face it, the problem part. Regarding the other part, that AI may be useful, that is the second word, trust. Let's trust.
Okay, that's crystal clear. Face it. Taking the bull by the horns, which is something that only crazy people in Portugal do. Embrace the problem. Thank you so much, Pedro, Bruno, Daniel. We need to wrap up. Thank you for sharing your wisdom on these very complex investigations in Europe and the Americas. I think it's clear that e-discovery is no longer a technical afterthought. It's central to the efficiency of modern investigations and the professionals who master it. So combining legal expertise with some technical understanding and also partnering with legal tech companies will be the ones who succeed. So thank you all of those that are following us remotely as well. We hope to see you soon at some of the forthcoming initiatives of the Knowledge Institute. So thank you, see you soon, and take care.
Thank you, bye-bye.
Thank you.
Bye. Bye.
Thank you. Bye.